want to place on the record than what is contained in your memorandum?
Very briefly, Your Honor.
Okay.
Your Honor, I pulled out 3 segments of the footage from Officer Park's body cam and from his dash cam, and it mirrors exactly what Your Honor pulled out. So I think the court and the defense are looking at the same things. It's very clear in that first segment, Stephen makes statements to the effect, or asking questions to the effect, why did they hit me? Why did they hurt me? Why did they punch me? Why did they chase me? In the second clip, he could be heard saying what I believe is, why were they trying to kill me? In the third clip, he says, I thought I was going to die. There's also a statement in the second clip, why did you make me do that? These are all statements that were made at the scene by the court, by the parking lot at Mountain View before Mr. Jones was transported to the police station. There's no dispute about that. And this is what Mr. Barker said as he stood in front of the jury 2 days ago. He's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. The defendant realized in that moment that he was arrested for a reason, that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. Right. But in that moment, in introspection, he knew that what he had done was wrong. Even the defendant doesn't believe he was justified. There's simply no way to listen to that and read this and come to a conclusion other than the fact that the prosecutor was being mendacious when he stood before the jury and made these comments and left them with the impression, intentionally, that Stephen did not articulate anything regarding the justification for his actions, his concern for himself, his concern for his friends, his belief he was acting in self-defense, until much later on when he was at the police station, after he had a chance to think about it and reflect, and in the words of the prosecutor, think about the kind of trouble he was in. What's particularly concerning about this, Judge, is that this was not some offhand remark the prosecutor made when he wasn't thinking. This was something, according to his statements yesterday and the day before, that he apparently had thought through and worked through with co-counsel. And after taking an opportunity to look at it, apparently thought that that was an appropriate thing to say to the jury. I don't know how one can credibly make that argument. I think the only question here is, what is the remedy? If we're not going to grant a mistrial, I think that the procedure that was followed in the Ninth Circuit case Robinson that I provided before is the appropriate remedy. In fact, I think the facts in Robinson parallel what happened here quite closely. And what I would suggest, Your Honor, is that we allow the jury to hear this. I would also suggest, Your Honor, because Mr. Chase Jones's statements at the scene were also something that the prosecution affirmatively fought to keep out, and that Mr. Stephen Jones, told Chase Jones, these guys beat me up, it was in self-defense, and directed Chase Jones's attention to Nick Plecki, expressing the defendant's concern that Mr. Plecki was going to try to take Stephen's gun. I think that comes in too, because the statement Stephen made to Mr. Jones, the statement that Stephen made in the back of Officer Park's patrol car simply can't be reconciled with this misstatement that the prosecution foisted on the jury. And I think if we're to remedy this and give the jury a fair, full, and accurate picture of what Stephen said and when he said it, they need to be told what Chase Jones heard, and they need to hear these 3 clips. Thank you.
Thank you. Mr. Barker.
I'll argue the motion, Judge, because I was the attorney that argued the motion to keep out the self-serving hearsay. Judge, I think we need to start with self-serving hearsay. It's not just self-serving statements, but self-serving hearsay. The statements were inherently inadmissible. We just had to bring that issue up with the court prior to trial so that we didn't have to deal with it during trial. They're hearsay, inherently inadmissible, and the court made that ruling. I also want to just point out before I begin, Judge, that this trial is a pursuit of justice, a pursuit of truth and justice. And the trial has, the evidence has gone to the jury for their deliberation at this point in time. And we're not just talking about justice for the defense, but we're also talking about justice for the victims. I think we need to keep that in mind, because the action that's already been taken at this stage may have already had an impact on our ability to find a just result. The concern of the state is that the jury began to deliberate on the case. It was given to them. They deliberated late in the day on Tuesday. They deliberated early in the day yesterday. It's not clear what the jury was told. It's not clear to the state anyways what the jury was told before they were sent home yesterday. I'm not sure what the bailiff said to the jury. You know, we work so hard over the course of a trial to make sure that you know, we limit what they get, what they see, what they hear, to only the appropriate things that they should be considering. I think it's hard to argue that them being sent home yesterday is going to impact their deliberations. I think that the court indicated yesterday, without the issue really having been fleshed out, that there may have been some wrongdoing on the part of the prosecutor. Now, we expect jurors to follow the admonition and not pay attention to the media, but the media has run with that. And since the issues weren't even fleshed out, it's probably, at least gives an inaccurate representation of what took place yesterday.
Are you indicating that you think that the jurors disregarded my instruction not to view or read any media articles?
It's just a further argument of the possibility that the action that was taken yesterday, may have already tipped the scale in favor of the defense.
Well, let me tell you, the bailiff didn't say anything. I went back and addressed the jurors, and I simply said, an issue has arisen that the attorneys and I want to address, and I'm directing you not to further deliberate, but to come back tomorrow at 9 a.m. and begin your deliberations.
All right, well...
The response was from the jury foreperson was, does this mean you're not going to buy us lunch today?
Well, I very much appreciate that, Judge. I'm glad to hear that interaction took place. I'll start by indicating, Judge, the appropriate way to deal with the situation that we currently find ourselves in, and that is to allow the jury to deliberate on what they have and to come to a verdict without further influence. And here's why. There was, in fact, no wrongful argument. Okay? There was no inaccurate argument. I think we need to talk about first what counsel actually argued in their motion for a mistrial after the trial. And that was that the statements that were excluded by the court, okay, that somehow Mr. Barker's argument wasn't consistent with the statements that were excluded by the court. I'd like to point out that there's at least 2 or 3 statements that have been raised this morning or raised by counsel in his brief that were never a subject of discussion of the motion to exclude the self-serving hearsay. Counsel never previously raised what is obviously a virtually inaudible statement on the part of the defendant, which literally I heard for the first time today. Nobody argued it, and the court never considered it before yesterday. That statement, I thought I was going to die, was never considered. The court didn't hear it when it reviewed the...
No, I did. And in fact, I did make that decision that statement, I thought I was going to die, was in fact self-serving hearsay statement.
Wow. And
that was precluded.
Yesterday, Judge, well, first of all, I don't remember any discussion of that. Counsel never put it in a brief. And yesterday, no aspersion to Steve, but yesterday we tried to get the record of the court's rulings and couldn't find any specific indication of that statement. What I remember the court ruling was the why statements. Why did they chase me? Why did they hit me? Why were they trying to hurt me? Okay? We start from the presumption that and from the knowledge that those are in fact self-serving statements. It's my argument, and I haven't seen the record indicating otherwise. And this will go to a further argument of the appropriate way to handle this situation. But it's my recollection, and I haven't seen a record otherwise that indicates that statement, any die or kill statement, was uttered prior to the defendant being at the station. All right? And so the truth is that there wasn't any wrongful argument, there wasn't an inaccurate argument based on what the parties knew. So if you look at specifically what Mr. Barker argued during his close, it's factually accurate, it's true. So I would argue that the defense is arguing a false narrative here, Judge. The court stated on the record yesterday that the court didn't remember the specific statements that were excluded. Defense counsel didn't argue the specific statements that were excluded. Defense counsel didn't argue yesterday, or 2 days ago, a die or kill statement. So we have to look at Mr. Barker's argument to determine specifically what it was that he was talking about. His argument was very narrow. His statements, he was talking about the statements that were made by those individuals in the specific circumstances those individuals were in. So it was the Nick Acevedo statement. I don't know. Why did you do that? I don't know. That was the defendant's response. Nick Pletke, the statements that were made to him were, or that he overheard, something to the effect of the defendant not knowing why he did it. Both of those statements, Judge, if you consider them in the context of time, came in between the two clusters of shots. That's the time frame that Mr. Barker was specifically referring to. When we're talking about the Labarro statement, that's in the cruiser after he had been taken into custody. And in that statement, he was asked, hey, was there anybody else? And he says, nobody else did anything wrong but me. The point of the argument was when direct inquiry was given to him, he didn't say self-defense. He said, I don't know why I did it. Nobody did anything wrong but me. And then Mr. Barker made the argument that no statements about kill were made until he was at the police station, which, you know, upon later specific review, and again, never having been previously argued by the defense, you can strain to hear something different. But we're only talking about misconduct if there's a good argument that it was actually known, and there isn't a good argument about that. And we'll get to how we know that in a minute. So what Mr. Barker said is actually true, but I guess, you know, reviewing much more closely, you could suggest otherwise. But
was this the state's CD?
Yes, Judge. But the argument that defense counsel made was that that counsel fought to keep statements out and then argued contrary to those. And what I'm saying to the court is that we weren't aware of those statements. We never argued to keep those specific statements out. Defense counsel never argued to get those specific statements in.
You didn't review that every single word that Mr. Jones made when you had that DVD?
We had the DVD, Judge. We didn't have a transcript of the DVD, which I'm sure counsel will agree with. And I had to kneel down like this, close to the speaker to even hear what the court's talking about here. So my point is that...
But you heard it.
Well, that's true, but the misconduct, Judge, the argument about misconduct is that he knowingly did something wrong. The counsel's not arguing that there was an error. Counsel is arguing that there was a knowing misrepresentation. And what I'm arguing is that this morning I heard that statement for the first time. I re-listened to these on my computer yesterday and did not hear those statements. Okay? They're very, very difficult to hear. So what I'm saying is that there's no knowing misconduct. Okay? It's an error, at best. And like I said, well, we'll get to it in a minute, but...
Let me see if I can short-circuit this, because I want to make sure that we get to the end of this. I've read the briefs, and counsel just, I don't mean this derogatorily, but I know that counsel want to put their arguments on the record. The record is the arguments that you've already made in your briefs. Okay? And so what I'm asking for is anything other than what you put in your briefs.
Yes, and I'll offer it, Judge, but in part, there's an issue because defense counsel raised what I would argue is new things in his brief, so, which I just got at 8 o'clock this morning.
The same as I did.
Right. So, if I may, Judge, I'd just like to flesh out the whole argument here. I'd like to refer to the Chase-Jones statement at this point in time.
Okay?
So, we've already had the discussion about the Chase-Jones statement. The state raised that statement. Defense counsel argued that statement. Defense counsel's arguing that the defendant said he was acting in self-defense to Chase-Jones. The state argued, we already had this discussion, the court already correctly ruled, that we don't know what the defendant said to Chase-Jones. The Chase-Jones told the police that there was stuff that the defendant may have said within that same statement, Chase-Jones said that he didn't know what the defendant said. The statement was precluded not just because it was self-serving hearsay, but the state would argue it was precluded because it's not actually a statement, we don't know what was said. I'll refer to the court's own words on the subject from that hearing. This is the court, quote, I mean, I don't see that Mr. Jones's statements show any indicia of reliability because that's Chase-Jones, by the way, because he doesn't even know what Mr. Jones said. And so those statements were precluded because they were filtered through another person who then admitted he didn't really know.
Okay, you need to, I understand you want to get on that, but for the purpose of the record, I've already stated what the record is that I'm considering it. And it has nothing to do with Mr. Jones's statements to Mr. Chase-Jones.
Well,
I already placed on the record what statements I'm considering.
Okay.
Okay?
Well, I think it's necessary to bring it up because that's the only arguably self-defense-oriented statement that was made during this period of time. These other statements are statements of maybe corroborative of facts that might subsequently support a claim of self-defense, but he didn't say they were self-defense. I was acting in self-defense. He said, why did they chase me? And I would suggest to the court that you'd need a heck of a lot more than somebody chasing you in order to be justified in self-defense. If I may, Judge, now I just need to catch up with my argument. I would argue that the defense memorandum and even the recordings we listened to this morning were not something that was being considered by Mr. Barker when he made his arguments. And again, I think it's important that the defense never argued them before. The case that the defense is citing to support its remedy in this matter is where the prosecutor argued facts that were not only not in evidence but were factually inaccurate. That's actually, and that the prosecutor would have known that they were factually inaccurate. That's a different circumstance than what we find here.
Okay, let me see if I can short circuit that. I read the briefs. I don't find that Mr. Barker intentionally committed misconduct. All right? So I'm not going to grant a motion for mistrial based on prosecutorial misconduct. I think it was, again, I continue to say that I think it was an inadvertent statement. I think it was one that he discussed with you about should he make that statement. I think that's a consideration of am I going to go up against, am I going to walk up to the line? The problem with that is that, unfortunately it's this guy in the black robe that gets to ultimately determine where that line is. And I think that line was crossed. But I don't think it was intentional. I don't think it was rises to the level of intentional prosecutorial misconduct. I think it was an inadvertent miscalculation. Okay. So I'm not going to grant the mistrial on prosecutorial misconduct.
All right, Judge. I'll skip on to my next point then.
Okay.
And the next point is that this is an untimely way to deal with this situation. It's not the correct way to deal with the situation because any action that's taken at this point in time will push the jury potentially in the wrong direction by highlighting evidence that look, the argument snuck by the defense. Okay? Either that or or they elected not to object to it at the time. A timely objection would have been the way to deal with this if they were really concerned about this situation. And I think it goes to also, when you talk about speech in the context of things and how they come across, okay, I think the court would agree that when you read things in a cold record, it comes across a little bit differently than it does in the moment when the argument is actually being made. And what we need to refer to is the impact that the argument had itself on the jurors. And I would argue that the impact is negligible or none because of the fact, and exemplified by the fact, that the defense didn't object at the time. They either didn't recognize it, weren't concerned about it, or strategically opted not to object to it. But if the argument were impactful, if they thought it were important, they would have objected to it at the time, and they didn't. So there is an expectation that objections come timely so that the appropriate remedy can be engaged in. If the court had found at that point in time that there was something that needed to be remedied, a corrective instruction could have been given, and that would have been, if necessary, and the state's not conceding it would have been, but if necessary, that would have been a seamless way of addressing the issue. At this point in time, to address it now would put undue weight onto the evidence that the court is proposing to give to the jury right now.
So let me ask, does a search for truth and justice end when the jury leaves my courtroom?
No, Judge, but a trial is not a perfect thing. A trial is a
Amen to
pursuit
that.
of perfection, right? And so decisions are made, decisions of whether to object or not object are made when the opportunity comes, when the opportunity comes up. And there's an expectation, the contemporaneous objection rule. There's an expectation that an objection should be made when there is grounds for it so that you can properly address it. And you know, when the jury gets the case, and to bring attention back or to offer new evidence is to place undue weight on that evidence. It's the reason for the contemporaneous objection rule. The appropriate way to deal with the situation is to wait until the jury finds a verdict, if they find a verdict, and then to deal with it as part of a new trial when all the parties have an opportunity to really think about this stuff, to actually have the record to refer to actually know what was ordered by the court at the March 23rd hearing, so that we can try to address the matter in the most appropriate way. I would argue, Judge, that the defense didn't recognize any problem with Mr. Barker's argument as it was given. It came at the beginning of the state's first close. The defense had ample opportunity to address it in a variety of different fashions. They could have objected at the time. They didn't. They could have addressed it in their close. They didn't. They could have asked for a curative instruction. They didn't. And what I suggest to you is that what those things give rise to is that there wasn't a noticeable impact of the argument at the time. So what we'd be doing if we did something different with the jury at this point in time is taking something that wasn't noticeable and making it much more weighty than it should be. We're not really, I agree with the court, we're not really talking about a motion for a mistrial here because obviously there's no misconduct that rises anywhere to the level that's required by the case law for prosecutorial misconduct or a mistrial in any fashion. The argument that we're talking about right now is properly the subject of a motion for a new trial under 24.1. So, and again, just some case law on that subject to the contemporaneous objection, Judge Estate v. Harris, to allow the defendant to permit an error to go unrectified and then, as here, claim the right to a mistrial or a new trial if he is convicted violates the contemporaneous objection rule. The time for what the court is currently considering has already passed. The jury's already begun their deliberations. They've already gotten the case. Now it's time to let the jury do their job and come to a verdict. Any other approach, Judge, I would argue, potentially creates a miscarriage of justice in the sense that now it's taking those scales that the court has worked so hard to keep even. It's taking those scales and just tipping them a little bit in the defendant's favor. And it's unfairly done. The defense could have addressed these matters, elected not to, in a timely fashion. And so the conclusion of my argument, Judge, is that obviously we're not talking about a mistrial. I would argue that the jury should be allowed to deliberate and come to a verdict, and then we can determine whether or not this issue had any impact. 24.1 is the correct approach. The state would argue that since the case is already gone and 24.1 directly addresses this particular argument, that the rule is that there isn't an appropriate way to deal with this at this time. We have to wait until the verdict comes. There obviously was no prosecutorial misconduct, and that Mr. Barker's argument was a fair and accurate argument at the time. If I may, Judge, I just want to ask Mr. Barker if there's any argument that he thinks that I've missed.
All right.
Judge, the only thing that Mr. Barker points out is that Randall, which I think is the case that the defense offered, is not controlling on this issue. We offered the court the controlling case law and rules that apply. Thank you.
All right, Mr. Davidson.
Thank you. Just a couple things in response to Mr. Shea's comments. I'm confident if the court inquires with its staff, it'll be able to take judicial notice that just yesterday the prosecution was provided the court's minute entry from April 13, 2017. On page 10 of that minute entry, excuse me. On page 2 of that minute entry, second paragraph from the bottom, the court advises it previously ruled the state can correct the court if the court is wrong, and it was made on the record. There are 3 why statements that the defendant made in the car, and then a statement to the effect, quote, I thought I was going to die. This is the minute entry that the state got yesterday. So I think that we should maybe view the assertion that they were completely unaware of what was on their own disclosure until 9 o'clock this morning with a jaundiced eye. I also think that it's important to note that Mr. Jones' statement that he thought he was going to die is not the only statement he made, which completely flies in the face of Mr. Barker's suggestion to the jury that Stephen didn't articulate anything related to self-defense until he was at the police department. I think the notion or the suggestion to this court that Mr. Barker's statement was very narrow and intended to suggest to the jury simply that Mr. Jones didn't use the word kill other than times after he was at the police station, I'm strained to find a reason even to respond to that, Judge, and I think it's self-evident why that just simply isn't a credible argument. I think that we also need to be mindful of the fact that this isn't a question of whether or not the court erred or didn't err when these statements were excluded. Our objection had nothing to do with Your Honor's decision to exclude these statements. We made a record on that. That's fine. Whether they were excluded properly or improperly, the fact of the matter is those statements were made. And when the state stands in front of the jury and makes a representation to them that is going to clearly leave them with the impression that statements Mr. Jones did make weren't made, that's not acting in the interest of pursuing justice. I'm sorry. That's acting in the interest of pursuing a conviction. And we should expect more from the prosecution in this case. The state relies on Harris to make the argument that the defense did not timely object. And in their next breath, they make the argument that we've raised this issue too early and it's premature and we should wait and see what the jury does before we could do this. Well, putting aside the internal inconsistency with the positions they're taking, we should also take a look at the case they're relying on, which, according to Mr. Shea, is more applicable than the Randall case that I cited. Harris didn't deal with prosecutorial misconduct or even innocent misstatements of fact or law to the jury in closing argument. Harris was a case about a jury selection process, something that happened at the very beginning of a trial when there was a late objection as to a motion to strike a juror.
It was a Batson challenge, wasn't it?
Yes, it was a Batson challenge. It's apples and oranges. I don't think, and I would challenge the state to find a case that more closely parallels what's happened here. Because in Randall, we not only dealt with a prosecutor that made a demonstrably false statement to a jury, we also dealt with a situation where it was rectified the following day. I didn't hear Mr. Shea talk about that, but that certainly also flies in the face of his argument that it's too late for us to do anything about it. Here we are 2 days later. There's nothing in Randall that says it has to be addressed at the time. In Randall, it was a day later. Here we are 2 days later out. The conviction was upheld in Randall. The Ninth Circuit Court of Appeals, last time I checked, this court is in the Ninth Circuit. I don't mean that to sound flip, Your Honor, but I believe it is controlling. And if the court follows the procedure that was approved of in Randall, I think that should be sufficient. I think because, and I don't want to leave the court with the impression that I am abandoning the defense position that the door has been opened to the statements to Mr. Jones as well. But if the court is not inclined to admit that evidence to the jury, although I think it should come in, we have the statements themselves recorded in a digital format, and they could be presented to the jury in a very concise and clear way without the need to reopen argument, without the need to call additional witnesses. I don't think it would be disruptive to the jury deliberation process. The only thing it would do is allow the jury to make a better informed decision and sift through the half-truths that were foisted upon them during closing argument. Thank you.
Judge, if I may.
No.
I was
No.
challenged to offer a case, Judge.
Mr. Shea, I'm done.
I was
Okay?
challenged to offer a
I
case.
understand that. I'm not taking any more argument. Please have a seat. I'm going to deny the motion for a mistrial. I don't find that Mr. Barker intentionally, with any kind of malice or calculation, deliberately or through some sleight of hand, tried to mislead the jury in this case. I do find, and the concern that I have, again, is the one that I stated. Where's my... The context is what I'm concentrating on, and I believe that either defense or prosecution, but both parties were sent this excerpt, and I'm reading from looks like page 5 of part of Mr. Barker's closing argument, and I'm starting at line 23. And then he says, now for all of those reasons, or any of those reasons, self-defense does not apply. But if you needed any further proof that what the defendant did was not self-defense, what did he say it was? That night, how did he talk about it? Because the defendant himself does not really believe he was justified. And then he goes into what he talked about to Mr. Acevedo, what he talked about to Mr. Pletke, and then it goes to Deputy LaBarle's statement. And that is the statements that I am concentrating on, because those were the statements that he made while he was in police custody. And he indicated, he's admitting right there that he did something wrong. He's not discussing that he was justified. He's not saying that what he did was correct or right. The defendant realized in that moment that he was arrested for a reason, that what he did was wrong. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me. Right. This is in the context of Mr. Jones' self-defense claim. And I don't think it's necessary, or I don't think there's some sort of magic incantation that for anyone to assert a self-defense claim, you have to use the word kill. I don't think that's required. There were self-defense claims, statements made by Mr. Jones that could legitimately be argued as self-defense. And the issue I have now, I wholeheartedly agree with Mr. Shea, is we have the trial is a search for truth and justice. This trial is continuing. The jury is deliberating. They're trying to continue this search for truth and to render just verdicts in this case. My concern is that they have been left, because the credibility of Mr. Jones' self-defense claim was put forward to the jury and put forward in such a way that it appears that the first time he raises a self-defense claim is when he is sometime into that 8-hour interview with the police, that the jury does not know that even prior to that, within 20 minutes of being placed into the police car, he was making statements that could have been legitimately argued, but for this court's ruling that those statements were self-serving hearsay. So what I am proposing is a curative instruction. Carrie, I just printed out 2 copies. Would you bring it out to council, please? And I'll give the parties 10 minutes to figure out what edits they want to do. I am proposing that the jury be instructed this way. Members of the jury, the court has determined that a statement inadvertently made by Mr. Barker during the prosecution's initial closing argument was inaccurate. The statement is as follows. Now, it wasn't until later, of course, when he had an audience with the police in a police station on the record that he started talking about, well, these people were trying to kill me, end quote. You shall be informed that Mr. Jones made the following statements while seated in Officer Park's patrol car and prior to his interview at the Flagstaff police station. 1, why were they trying to hurt me? 2, I thought I was going to die. You are to consider these statements as evidence. As such, you are free to accept these statements in whole or in part and to give them as much weight as you feel they deserve. We'll stand at recess for 10 minutes. Let me know what you think.
All right, everyone. So as you heard from the judge there in the NAU shooting trial, he has denied the motion for a mistrial, but he does want the jury to know that the prosecution made an incorrect statement during closing arguments. That is what he has proposed. He's now taken a 10-minute recess. I do want to recap some information for you in case you missed our coverage of the NAU trial yesterday. There was a special hearing yesterday, and the judge suspended jury deliberations. I want to give you guys some background information. The judge overseeing this trial for Stephen Jones accused of murder and assault for fatally shooting 1 NAU student and wounding 3 others, halted jury deliberations yesterday. The judge concluded that jurors received misleading information from the prosecution during closing arguments. The judge said yesterday that the prosecution erred when jurors were told that the suspect didn't tell police he feared for his life until after he was taken to a police station. The reality is there was information to suggest that Stephen Jones did indeed say or suggest that he feared for his life when he was in the patrol car. However, a month ago, the prosecution filed a motion that it did not want the jury to hear and see Stephen Jones sitting in the cop car crying with a bloody lip. The state asked the judge to withhold that video from the jury, and the jury never got to see it. So that's what's going on right now. That is the issue that the judge just brought up, and we are now on recess for a few minutes. We will resume coverage of this momentarily.